An Ohio Sheriff's Department picked the wrong fight. About 3 years ago, they raided the home of the rapper Afroman, broke his beloved front gate, and kicked down a charming side door. Over 3 years later, Afroman was put on trial. Not because of any crime he committed, the police found nothing incriminating in their raid. No, he was on trial for what he said about the police raid in a viral music video.
Why are you stealing my money?
7 Ohio sheriff's deputies filed a defamation lawsuit against Afroman, alleging his music video caused them immense harm. But Afroman and his attorneys obliterated them in court, and it was all caught on camera.
All of it is an outrage.
So today I'm going to break down how Afroman and his legal team beat the defamation case and answer the question he's been asking for the past 3 years.
Will you help me repair my gate and door?
This is Winchester, Ohio, population roughly 1,000, a small town in Adams County about 50 miles east of Cincinnati, and the county itself only has about 27,000 people. And on this Sunday morning, heavily armed sheriff's deputies are about to make a very big mistake. Enter Joseph Edgar Foreman. Born in 1974 in Palmdale, California, you know him as Afroman, the guy who gave the world Because I Got High in 2000. The song was a goofy anthem celebrating weed that went to #1 in 23 countries and got nominated for a Grammy. Afroman was everywhere.
I was gonna go to court before I got high.
But by 2022, Afroman had traded the limelight for a quieter life in Winchester, Ohio, where he lived, performed locally, and made music on his own terms. He had a home studio, security cameras on his property, and cash from gig earnings stored in the house. He was not, by any apparent measure, a drug trafficker or a kidnapper. Someone, however, had told the Adams County Sheriff's Office otherwise. On August 21, 2022, the Adams County Sheriff's Office obtained and executed a search warrant on Afroman's home. The warrant alleged suspicion of drug trafficking and kidnapping.
The warrant said narcotics and kidnapping. The warrant said narcotics and kidnapping.
The basis? A confidential informant. Afroman wasn't home when they showed up, but his then wife and their 2 kids, aged 10 and 12, were nearby. They came over when they saw the police presence. She recorded parts of it on her phone, and there's also body cam footage. According to Afroman, the deputies kicked in his front door, broke his external gate, cut the wiring on his security camera system, rummaged through his closet, flipped through his CD collection, handled a wad of cash found in the home, and encountered 1 lemon pound cake baked by his mother. They found no drugs, they found no kidnapping victims, they found no evidence of any crime. They didn't even find the basement torture dungeon the confidential informant described because, well, apparently Afroman's house didn't even have a basement. Needless to say, no charges were ever filed. But they did leave behind something priceless: security camera footage. Afroman came home to a trashed house. His front door was destroyed, his security system was cut, his property was in disarray. He reached out to the sheriff's office about repairing the damage. He says their response was essentially, not our problem.
The guy started laughing and waddling his head. He goes, "We're not required to do that." And they were unapologetic.
Afroman actually filed his own lawsuit over the damage to his home, but that claim was dismissed, and that's because the law gives police a lot of leeway here. When officers execute a valid search warrant, they're generally allowed to use reasonable force to get inside, even if that means breaking doors or damaging property. And courts have held that kind of damage doesn't automatically require compensation. So even though nothing was found, and even though Afroman was left with the bill, the law still treats the raid itself as lawful. He also says the deputies had confiscated over $5,000 in cash, money he made from performing. Eventually, they gave it back, but Afroman claimed about $400 was missing. The sheriff's office said deputies simply miscounted. But Afroman was not convinced. So he asked himself a question that would kick off this entire saga.
I asked myself, as a powerless black man in America, what can I do? And only thing I could come up with was make a funny rap song about him and make some money, use the money to pay for the damages, and move on.
His answer? Make a funny rap song about it. 4 months after the raid, in December 2022, Afroman released the first music video.
There are no kidnapping victims in my CD. Did you find what you was looking for? Will you help me repair my gate and door?
Then came the masterpiece, Lemon Pound Cake. Set to the tune of the Drifters song Under the Boardwalk, the video slows down on a deputy who, in the middle of executing a search warrant for kidnapping victims and narcotics, pauses at a cake stand in Afroman's kitchen and stares at a lemon pound cake baked by Afroman's mother.
He sees my cake and my porno mag call boom boom. Something happened to his camera on the way to the evidence room. Mama's lemon pound cake, it tastes so nice. Make the sheriff wanna put down his gun and cut him a slice.
The video now has over 3.7 million views on YouTube. Afroman didn't stop there. He created an entire lemon pound cake album. He made merchandise featuring the deputies' likenesses. He nicknamed the cake-gazing officer Police Officer Pound Cake on social media. He compared the judge who signed off on the warrant to the cartoon character Droopy. He compared one officer to Quasimodo.
Is it true that Mr. Foreman called you a hunchback?
Yes.
And specifically compared you to Quasimodo?
Yes.
He released more videos. He posted on TikTok, Instagram, YouTube, and Facebook. He called them being from Adams KK County and accused them of theft. Then he released a song allegedly about sleeping with one of the deputies' wives. The deputies were not happy.
Now, we've talked extensively on the channel about the rise of authoritarianism in the US, and that means that independent media is more important than ever. So if you want to support our mission to demystify the law as independent creators, a great way to do so is by signing up for Nebula, the sponsor of this video. Nebula is the streaming service that my friends and I built where you can watch all the content from your favorite creators like Jetlag, Maggie May Fish, Real Engineering, PhilosophyTube, Real Life Lore, and of course, LegalEagle, all ad-free and early. Plus, watch countless Nebula exclusive videos made with love, time, effort, and increased budgets that you won't find on YouTube. I highly recommend you check out Lindsay Ellis's original documentary, The Macabre World of Police Body Cam YouTube. It's a fascinating expose on how this wildly popular genre of true crime content is altering social attitudes about law and policing. And check out our exclusive videos about how to abolish ICE, the wild and forgotten attempts to ban booze in America, and how RFK Jr. can and cannot legally ban vaccines. But the only place you can watch these videos is on Nebula. In fact, every LegalEagle video we make is an extended cut on Nebula, like the legal analysis of improv comedy scenes I did with Brennan Lee Mulligan, or my beatdown of Kim Kardashian's hilariously bad legal drama, All's Fair. Both contain a ton of more insight and hilarious moments that we had to cut from the YouTube version. And if you use my link or code, you can get 50% off an annual subscription, or 40% off the lifetime deal of Nebula. You can pay once and then never again. Either way, click or scan now to continue watching LegalEagle on Nebula, or I'll see you in court.
In March 2023, 7 Adams County Sheriff's deputies filed a civil lawsuit against Afroman. The claims included defamation, invasion of privacy, false light, and commercial misappropriation of likeness. They said Afroman used their images without permission and profited off their faces and personas. They said he told lies about them. They said they had suffered humiliation, ridicule, mental distress, embarrassment, loss of reputation, and even death threats. One deputy, and we'll just let you guess who, said anonymous people had mailed pound cakes to his workplace. Multiple pound cakes. Is that supposed to be a bad thing? And what did they want? Nearly $4 million in damages. Afroman's response was immediate. He filed a countersuit, and he had allies. The ACLU of Ohio filed an amicus brief calling the lawsuit a classic slap suit, a strategic lawsuit against public participation, describing it as a meritless attempt to silence criticism. In the meantime, a local judge eventually dismissed 6 of the 8 claims in the officer's lawsuit against Afroman. However, the judge kept 2 claims alive, false light and defamation. They're closely related, but both run headfirst into the First Amendment. Under Ohio law, defamation protects against false statements of fact that harm a person's reputation. The elements are familiar to LegalEagles by now. The plaintiff must show that the defendant made a false statement, it was published to a third party, the defendant acted with the requisite intent, and the statement hurt the plaintiff's reputation. When the plaintiff is a public official or public figure, courts require proof of actual malice. And that means the speaker knew the statement was false or acted with reckless disregard for the truth. The key point is that defamation is anchored in falsity. It's not enough that speech is embarrassing, insulting, or critical. The Supreme Court of Ohio recognized the tort of false light in Welling v. Weinfeld. False light does not require a specific false statement. Instead, it targets situations where someone is placed before the public in a misleading way, one that would be highly offensive to a reasonable person. False light differs from defamation in that it focuses on misleading and highly offensive impressions, such as the impression made during a music video, rather than on specific false statements. But even here, falsity still matters. The claim depends on a false implication, or a false overall impression, not just an unfavorable or embarrassing one. The Ohio Supreme Court emphasized that to prove false light, the plaintiff has to show actual malice, mirroring constitutional defamation standards because the First Amendment still applies. And there's good reason for that, because once you move from false statements to false impressions, you're getting dangerously close to punishing speech simply because it offends. And that's where the First Amendment draws a hard line. There's a defense that cuts across both defamation and false light: parody. If no reasonable person would take the statement as a literal claim of fact, it's protected. And that was the core of Afroman's defense, that his music and videos were expressive, exaggerated, and not meant to be taken literally. But the defense didn't stop there. If the footage used in videos is real, and the events depicted actually happened, then the resulting portrayal, even if humiliating or critical, is not necessarily false. And without falsity, neither defamation nor false light can succeed. So how did this case wind up going to trial? The local judge concluded that for purposes of false light, Afroman publicized false facts about the cops, which would be highly offensive to a reasonable person. These allegations, he said, were sufficient to state a claim. The judge also held that the deputies had a viable defamation claim. Allegations that the police stole money or used drugs were the type of statements that would cause reputational harm. The court did not agree that these statements constituted opinion, as they were each provably false. The judge's reasoning here is not all that persuasive. It is true that Afroman's allegations about corruption and lying could offend an average person, but the judge is overlooking the very big elephant in the room. Afroman made his claims in the context of songs that included parody and satire, and that kind of speech is generally protected by the First Amendment. We have Jerry Falwell to thank for that. Falwell sued Hustler magazine for running a fake ad for Campari liquor, recounting how Jerry lost his virginity to his mother. Falwell asked the Supreme Court to apply an outrageousness standard that would have allowed a jury to impose liability on the basis of the jurors' tastes or because they don't like certain expressions. But the Supreme Court held that public figures cannot recover damages unless the defendant made a false statement of fact with actual malice. And that paved the way for Afroman to write Lemon Pound Cake and South Park to depict President Trump in a sexually intimate relationship with Satan.
Stop!
You may find the Falwell ad or the South Park episodes or the Afroman videos funny, or you may think they're crude. In any case, he likely had a constitutional right to make fun of the deputies. It's also worth remembering that saying cops are crooked or corrupt is opinion. And when the government kicks down your door, the Constitution protects your right to say you don't like it. TLDR, if the verdict had gone against Afroman, I don't know that it would have been upheld on appeal. Afroman's countersuit was dismissed before trial. That means Afroman couldn't make the sheriff fix his door. 3.5 years after the raid, the case finally went to trial, and it was all documented on video. The deputies testified first. Here's the Pound Cake guy, Sean Cooley.
You were called Officer Pound Cake by Mr. Foreman?
Multiple times.
And the context of that name comes from a music video that Mr. Foreman created, correct?
I don't know where he got it at, but
The Adams County Sheriff kicked down my door. Then I heard the glass break.
You would admit that you with the glasses walking by the lemon pound cake on the counter?
yes.
This clip isn't just funny, it does good legal work. Remember, for false light and defamation, he has to prove that Afroman said something false. But here, he admits the underlying event is real. That's him in the house, in the video, walking by the mom's dessert with what a reasonable person might describe as lustfulness. What Afroman added was the label Officer Pound Cake. But that's not a factual claim, it's a joke, a characterization, the kind of exaggeration the First Amendment protects. This is also a classic approach to parody. Take a real event or a real person, exaggerate it, turn it into a character. Officers from other jurisdictions also call him Pound Cake.
When I walked into the deputy's room up there to talk to them, they all knew me, all knew that I'd been called a thief, lemon pound cake. He has posted my image, yes, several times on the internet. He's sold merchandise, sweatshirts, T-shirts, things of that nature at all of his venues. Matter of fact, they were for sale at a smoke shop here in town.
Now that could be humiliating and hurtful, but he can't get damages for emotional distress if he doesn't prove the other elements of defamation and false light. Here's another good moment of cross-examination by Afroman's lawyer, David Osborne.
This may sound stupid, but I believe it applies to myself. We're not the thinnest people in the world, are we?
I'm not going to call you fat, but okay.
I was calling myself fat. But you would agree that we're not thin people.
Absolutely.
And you would agree that how you conduct yourself during a search and everything reflects directly on your reputation?
Absolutely.
You don't believe everything you read on the internet, do you?
No.
You actually probably don't believe everything you read in the newspaper, do you?
No.
You would agree that Exhibit D that I played, the song Lemon Pound Cake, is a music video for entertainment?
There again, he made accusations that I smoke weed on there, which I don't.
So
that was a lie as well.
So you are suing based upon him saying you smoked weed in a song?
I say that goes along with some of the other rhetoric that he's told about us, lies he's told about us.
Okay.
Here, Osborne gets Cooley to agree that some comments, like calling someone fat, aren't really provable facts, they're opinions. Then he walks him into something even more important. Cooley admits he doesn't believe everything he reads online or in the media. Whoops, that's the reasonable person standard. Because if people don't take everything literally, then a song, which is obviously meant as entertainment, is even less likely to be understood as a factual claim. And once the case is framed that way, it starts to fall apart. The defense called just one witness besides Afroman. That's Rhonda Grooms, a teacher and the ex-wife of Sheriff Deputy Sean Grooms. She was asked whether she and her students were familiar with the Cardi B song WAP. Grooms testified that they all knew the song and nobody took WAP seriously.
Are you familiar with the song Wet Ass Pussy?
Yes.
Has your students played it in class?
Once, and I asked them to please turn it off.
When they were listening to it, did they think that was fact?
No.
So they didn't think that that was depicting anything in real life?
No.
So you didn't have to teach them that wasn't real?
Right. No, I did not.
Would you agree it's derogatory towards women?
No.
Even though it says nasty things about them?
Yeah. No. I mean, it's the artist's opinion, I guess. That's the way I feel.
What's even worse, his ex said he wasn't devastated by his portrayal in the video for Lemon Pound Cake. Imagine being able to own your ex by testifying that he doesn't really understand the law and he was lying about being mortally wounded by his song. This was a devastating moment for the plaintiffs, and not just because of the personal dynamic. Her testimony did two important things legally. First, it reinforced the defense's core argument that these songs weren't meant to be taken literally. By comparing Lemon Pound Cake to a song like WAP, the defense was showing the jury that it's a genre built on exaggeration, shock, and humor. Rappers are not exactly known for their factual reporting. In other words, the same point underlying the parody doctrine, no reasonable person is treating these lyrics as statements of fact. Second, it went straight to damages. Grooms claimed he was deeply harmed by the song, but his own ex-wife testified that he laughed about it. That undercuts one of the key elements of emotional distress, that the harm was real, serious, and severe. So this wasn't just embarrassing, it was legally fatal. It's hard to claim a song destroyed your life when you were laughing about it. And since the jury did not find in the plaintiff's favor, it's likely they thought her testimony was at least somewhat credible. But Afroman's lawyer was making a key point. Artists tend to make exaggerated claims, particularly in rap, but come on, also in country and other genres. The lawyer pointed to one song in particular, Lil Wayne's Pussy Monster.
Nobody looks at Lil Wayne's song Pussy Monster and says there's a monster in that song. Everybody knows it's exaggeration for entertainment. Is he commenting on something? Sure. But it's not fact.
That was arguably the same thing Afroman was doing in the songs about Adams County. Some of the things the deputies found offensive were not facts, but matters of opinion. For example, one song calls Deputy Randy Walters a son of a bitch.
Randy Walters is the son of a bitch.
When asked about it, Walters notes of his mother that she's been dead for years.
When they call you a son of a bitch, that would be an opinion?
I'd say that would be an opinion.
Okay. Because there's no way we can prove whether you're a son of a bitch or not.
Nah, she's been dead for years.
I'm sorry. I am sorry about your mother on that. I am. But you would agree, though, that when someone calls someone a son of a bitch, it's not necessarily a statement of fact. It's more a statement of opinion or a description of a person.
Sure.
The same thing with being called, I think it's Gomer Pyle.
Yes.
Okay. No one would think you're Gomer Pyle from the movie?
Obviously, that's a character in a movie.
Yeah. But you're not that person.
No.
This was an effective cross by Osborne. It went directly to the legal standard. By getting Walters to admit that calling someone a son of a bitch isn't something that can be proven true or false, the lawyer established that it's an opinion, not a statement of fact. Then he took it a step further. By walking through even more absurd examples, like comparing Walters to Gomer Pyle, Osborne showed the jury that these weren't factual assertions at all, but exaggerated comedic descriptions. In other words, the kind of rhetorical hyperbole the First Amendment protects. Sergeant Walters testified that one of the most harmful things Afroman did was suggest in a song that he had slept with Walters' wife.
He said he had sex with your wife.
Yes.
Okay. And that's painted you in a false light.
It's caused tremendous pain in my life.
But under cross-examination, things got more complicated. When pressed, Walters struggled to say whether the claim was actually false or even verifiable, at one point responding, "I don't know," when asked directly if the statement was untrue.
Does it paint you in a false light?
Yes, that my wife is cheating on me with Mr. Foreman.
But we all know that's not true, correct?
I don't know.
The point isn't whether the claim is true, it's whether the law treats it as a factual assertion in the first place. But this shows how easy it is to get tripped up on the witness stand. His answers probably damage his case. False light and defamation both require some connection to falsity. But here, the alleged harm rests on a claim that even the plaintiff seemingly couldn't clearly define or disprove. At the same time, the statement comes from a rap song, an expressive medium that audiences don't typically interpret as a literal fact. So instead of showing a provably false statement, the testimony ended up highlighting the opposite, that this is exactly the kind of hyperbolic speech the First Amendment is designed to protect. But then Afroman took the stand. And a little side note, when a defendant shows up looking like this, plaintiff's attorneys would be wise not to underestimate them.
And because they executed a search warrant on your home, that gave you the right to post the things that we've seen this week on the internet?
Because
Is that right? Is that right, Mr. Foreman?
Yes, for
Yes.
tearing down my door, not paying for it, not being apologetic, me being a sport, doing something peaceful to raise the money to pay for their damages, me having the right of the freedom of speech as an American to talk to my family, friends, and fans about what the sheriffs did to my home. Yes, I had the right to my freedom of speech. After they left, I had the right to kick the can and to do what I had to do to repair the damage they brought to my house. Yes, I did.
That includes the right to post the videos that you've just been posting up until Friday and beyond, right?
Yes, I have freedom of speech. I'm a rapper. I entertain. I write fiction, comedy. Yes, I mean, I entertain for a living like you practice law for a living. So I have to go to work.
The lawyer tries to suggest, hey, you took advantage of the warrant to make money. Afroman effectively flips that back the other way. He didn't make the videos to be vindictive. The deputies created this situation. They tore down his door, ripped up his home, and refused to pay for the damages. That reminds the jury of who started it. But it's also a subtle way of pointing out that this lawsuit is actually retaliation against him for exercising his First Amendment rights, not the other way around. He clearly labels his conduct as entertainment. He writes, he performs, he entertains. He's not a reporter. He also recites the legal standard in a down-to-earth way. It's not easy to define the reasonable person standard, but he does that here by saying, I have freedom of speech, I talk to my family, friends, and fans, and they have opinions about these videos. I also think he did a fine job of humanizing himself. He goes to work every day just like the lawyer, just like the jurors.
You remember in your deposition when I asked you why did you bring the news when you picked up the money?
Yeah, I didn't want to get beat up or Epstein at the sheriff's station after I seen him running around my house with AR-15s. So that's why I brought the news and my attorney. So to make sure I got out of that place with my money.
You brought the news to protect you physically.
Yeah.
Yeah. You didn't bring the news because you already knew there was a miscount and you were going to make.
I didn't know nothing about the miscount. I didn't know. I figured they stole my money. They turned my cameras off. So if you turn my cameras off, you must got something bad in mind.
Again, in this clip, the lawyer seems to be suggesting that he was trying to set up the deputies or create a spectacle by bringing in the news media. He countered that by saying he had a reasonable concern about what would happen to him based on how he had already been treated by the sheriff's department.
In all circumstances, the jury finds in favor of the defendant. No plaintiff verdict prevailed.
In the end, the jury sided with Afroman. And once you walk through the law, that outcome isn't especially surprising. The deputy's case depended on turning songs, jokes, and edited footage into provable false statements of fact. But much of what Afroman created looked exactly like what the First Amendment protects: exaggeration, criticism, and commentary about government actors. If a reasonable viewer wouldn't take it literally, then the defamation and false light claims are dead on arrival. And maybe that's what this case is really about. Not just whether Afroman said something false, but whether he could be punished for saying anything at all. We've unfortunately seen this before. In the Novak v. City of Parma case, another one involving the Buckeye State, a local man was arrested for parodying his local police department on Facebook.
Anyone seen outside of their home from the hours of 12 p.m. to 9 p.m. will be arrested. Thank you. Some people, I'm sure, were confused about it, but most people responded to the fact that it's clearly a parody. Parma Police Department did not like my page.
Different facts, same problem. Local police didn't want to be criticized, so they retaliated against citizens who mocked them. But the Constitution doesn't guarantee that criticism will be fair or polite. It protects the right to be loud, mocking, and even offensive when you're speaking about the government. And that brings us to the part of the story that's a little harder to see, but just as important. This case didn't start with a raid, it started with a confidential informant. The law recognizes that confidential informants can be unreliable. They may have a motive to lie or exaggerate, or they may be seeking leniency in exchange for information. That's why officers are supposed to corroborate at least some of what a CI says before using it to establish probable cause. The rule comes from Illinois v. Gates, where the Supreme Court said that when presented with a search warrant, judges must look at the totality of the circumstances, including whether the informant is credible and whether police corroborated any part of the informant's tip. Because without that verification, a tip isn't evidence, it's just a story, and if that story is wrong, the consequences are real. Thankfully, no one was hurt during the raid on Afroman's house, but people have been injured and killed during raids based on faulty information from confidential informants. When that happens, the damage can't be undone by a parody song. But two things unquestionably were hurt in the raid: Afroman's beautiful gate and his tasteful door with a sunburst window. So now that he won his case, will the state of Ohio finally help repair them? Unfortunately, no. His lawsuit for damages was dismissed because the warrant was lawful. Deeply flawed, but lawful. And unfortunately for Afroman, he's also probably on the hook for all of his attorney's fees because the defamation case against him was filed before Ohio enacted its anti-SLAPP statute in January of 2025. But there is one silver, platinum lining here for Afroman. The internet never forgets. And so when it's the night before your trial, and this banger is what you put into the world, you're probably going to end up with all the gates and doors you could ever want.
Mine eyes have seen informants get busted with felonies. Tell the cops I'm a kidnapper and I sell a lot of keys. Raid my house and then get pissed, 'cause the dungeon don't exist. My proof's on the internet.
Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems, and they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel? Transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.